Our webinar is going to be about the Yale settlement, and that's turning that existential lemon into existential lemonade. And Al Lewis will be leading our discussion. And we have a special guest who is one of the country's foremost lawyers in EEOC and wellness law, or wellness law as it relates to EEOC concerns. And I'm going to start by briefly introducing Al Lewis, who most of you know. Al is recognized as one of the country's foremost authorities on wellness and population health. He's authored a book on that. He authored another book with Tom Emmerich, who managed benefits at Walmart for more than a decade, and that was about cracking health costs. Many of the concepts that they talked about in that book are going mainstream in corporate plans now. What you may not know about Al is he also has a degree from Harvard Law School, and he spent a lot of time looking at the changes at the EEOC and how that may affect how you manage your wellness program. So I'm going to turn it over to Al, and he's going to introduce our special guest, and we'll go from there. Thank you.
Thank you very much, Mark. First, the usual disclaimer. This webinar does not constitute legal advice, yada, yada, yada. And the agenda is that we will have our special guest on for a while, and that the Q&A box will be open. In fact, it looks like we already have one in. I'll get to that in a sec. And then we'll go into what's compliant and what isn't, and how to avoid exposure and stay compliant. As Mark mentioned, there will be polling questions throughout. I will also, and in the background is basically as follows. There are no more rules interpreting the Americans with Disabilities Act. The word voluntary, I believe it's actually involuntary, appears in the ADA. It used to be that voluntary could mean whatever you wanted it to mean. Then with the rules gone, you have to look at the actual law itself. Voluntary means no incentives, no penalties, which means most clinical programs have been in technical violation of the ADA for 2 years. Now, finally, someone, in this case, Yale University, was pulled over. With that, I will pass the torch to our special guest. And while I introduce our special guest, Mark, I believe you have a polling question to ask. Do you tie a specific incentive, penalty, or premium differential to your wellness program, checkup, screening, coaching, etc.? And while you're answering that, I will introduce our speaker. Now, I looked the statistic up before I got on the show, and I find this just mind-blowing. There are 1.3 million attorneys in this country, 1.3 million. We today have the only one of that 1.3 million whose specialty is wellness law, has written widely on it, has going to trademark health and wellness law, I believe, right? And we were just thrilled to have Barbara here today. But before we jump into, before I turn it over, Mark, do we have a? Okay, so well, actually, this is down from Barbara and us did this a couple of years ago, and the yeses were considerably higher than the no's for do you have an incentive. So people actually seem to be taking this seriously already. And with that, Barbara, take it away.
Great, thank you. Well, so my role here is to really give you the background on the Quizzify versus Yale University. It was a class action lawsuit. And I was hoping that the litigants would have joined us today to talk about their thinking behind the lawsuit. But Al, you mentioned that you were unable to get them to join us.
Yes, Barbara, I'm glad you mentioned that. So I offered both. Both turned us down. The AARP could not have been more gracious about it. You know, would love to join, but I could not go on what was, she said, quote unquote, I can't go beyond what was in the press release. Yale, on the other hand, I think has sore loser syndrome here. So they couldn't join. So Barbara, thanks for asking. Back to you.
Yeah. So I'm glad you mentioned AARP's role in this, because obviously they're not mentioned anywhere in the lawsuit itself, but they were behind helping the plaintiffs, Lisa Quisel, I don't know if I'm pronouncing her last name correctly, and the other plaintiffs, they were behind helping them try to bring this case against Yale University. And so it's important to remember that this case was brought in July of 2019 when the EEOC's rules under the ADA and GINA, which had provided some definition around that word voluntary, still were in existence. And so those rules were about to get yanked, but they hadn't. And so now the court had to deal with the statute, that word voluntary, and the voluntary, to give you some context, wellness programs that are offered to, well, anyone, employees, or if it's part of a group health plan, it doesn't matter. If that wellness program has as part of its program structure the collection of health information from employees, and if they're collecting health information from family members, either through the usual suspects of a health risk assessment or a biometric screen, or in the case of this wellness program offered by Yale, asking employees to undergo preventive screening tests pursuant to the U.S. Preventive Task Force guidelines. And if that counts as a medical exam, preventive screening counts as a medical exam. And the EEOC has said in, well, the statute of the ADA, Americans with Disabilities Act, that you can't ask employees to do that and undergo such an exam unless it's part of a voluntary wellness program. And for a while, for just a few years, we had some context of what voluntary meant as far as numbers that can be assigned to an incentive amount, but that disappeared a couple of years ago now. And so we're left with the statutory language again of voluntary, which isn't defined anywhere. It's not, there's no number assigned to what means voluntary when it comes to incentives or penalties. And so the employees of this, who belong to two unions, local union 34 and local union 35, sued their employer, Yale University, because they felt that the incentives that were offered, or penalties that were offered as part of this preventive test wellness program were not voluntary. It didn't make those tests voluntary. And so the wellness program that they were suing about was called the Health Expectations Program, HEP. And that HEP was negotiated between the unions and Yale University. And so that was like a key argument that Yale University used to push back on the employees' lawsuit, was that, hey, you guys as the union members negotiated this wellness program, and it was in exchange for keeping your health plan benefits at no premium, no deductible, no copay, basically free of charge. But in exchange for that really generous health plan that we're offering our employees, we're asking you, if you fall within the USPTF guidelines of getting these preventive exams, you know, you meet the age requirements and the time in needed. This slide showing you the the chart that the USPTF provided to show when you should be getting your mammogram and your breast cancer screening and your diabetes screening. If you fell within those categories, you should be getting them. And if you do, then you don't have to get a $25 penalty a week. But if you don't, then you will get the $25 penalty per week.
So a couple of items really quickly here. First, we do have some attorneys on the call, so it's very important to say that the specific part of the rules regarding the penalties is what's got shut down. The voluntariness, the part we're talking about. The other rules are still in effect, but this is the one that's relevant for us right now. The other thing that came up is, of course, a very good question is, what is a significant, and this came up in the context of the poll, somebody said, what is a significant penalty or incentive? And my view is if you have to ask, it's not significant. But, you know if it's significant, right? Hundreds of dollars. We don't know where the line's going to be drawn, right?
Yeah, right. Well, and I always say that it's subjective. When it comes to enforcement of the ADA, especially in the wellness program arena, what constitutes voluntary, a voluntary HRA, a voluntary medical exam is going to be subject to the perception of the employees who are being asked to undergo those activities. And you have to remember that the tension here is, do I get the exam or answer these private private health related questions, or in exchange for some incentive or penalty or avoiding a penalty, or do I give up this, what I believe is private information? So the tension is between protecting one's privacy versus getting involved with a wellness program that would ultimately have you reveal some sensitive information about yourself to your employer or group health plan.
So a couple of points here, actually, before we go on to this one. This last slide here, oops, I can't, my chat box is up. So here we go. This last slide, shockingly, this is actually a very good set of things to do. It's very compliant with the USPSTF, although they've changed their rules a little since then. And if it hadn't been for the fact that all these penalties and this horrible invasion of privacy, and Barbara, do you remember what the actual plaintiff, what happened to the actual named plaintiff in this case?
I'm having trouble remembering.
You would remember if you knew. She was the one who was told if she didn't get a mammogram, she'd be penalized. And she said, but I've had a double mastectomy. And the coach said, that's no excuse. So I mean, you want to know why someone sued? That's why someone sued. So speaking of which, take it from here.
Yeah. So this is a quote right from the complaint that was filed by the plaintiffs in this lawsuit. And I think it captures basically the frustration that the plaintiffs were feeling. Since they're not here, we can't ask them directly, but I think this quote has a really good just summary of why they brought the lawsuit. The weekly fine is a high price to pay for privacy and protection from discrimination. It has real life consequences for those members of the class who do not want to disclose sensitive medical information or subject themselves and their spouses to intrusive medical exams and testing at their employer's behest. Indeed, for members of local 34 and 35, whose base pay can be as low as $16.92 an hour. So that last part of giving their hourly wage really plays into this concept of voluntariness is really in the eyes of the beholder. Here we have some union employees who make just above minimum wage, if it's $15 an hour, depending on where you're at. And, to pay $25 a week in exchange for giving up, keeping your health information private was not what they viewed as a voluntary action. So that was a lot of money for them. It works out to be about $1,300 a year, and that can buy a lot of food on the table or pay rent or whatever else is necessary for them at that kind of wage.
And that was precisely what Judge Bates said in the original rule where he struck down the penalty provision, exactly what you just said and what's in here. And the other thing to add is that these are penalties, but if you take a regular old health plan and you increase the deductible dramatically, and then you say, well, we'll give you an incentive, the judge was very clear that incentive is the same as penalty.
Mm-hmm. Mm-hmm. Yeah, I mean, that's in the law, especially if you look at the HIPAA and Affordable Care Act wellness incentive rules, that it's a reward, that's the technical term they use in the HIPAA Affordable Care Act. rules is considered either a penalty or an incentive. It can be either way. Obviously, bonuses and positive reinforcement is going to be perceived differently than negative reinforcement and penalties, but the law treats them the same way.
Barbara, we got a question here that I think I know the answer to, but since I have the 1 in a million with me here, I'm not going to answer 1 in 1.3 million person here. I'll let you answer it, which is that was Yale itself getting these results, or these were just being shared amongst the vendors?
It was being shared with the vendors. I don't recall if Yale was getting the results. They can get aggregate results under the ADA. Again, we're focusing on the ADA right now. They can get aggregate results. They can also get individualized results if they need it for plan administration. So the law permits disclosure to the employer, the sponsor of the wellness program, if the employer needs that information for plan administration. For example, if the employer is responsible for notifying the employees of who has to pay the penalty and those kinds of things. I don't recall what the arrangement was between Yale and Trestle Tree, which was one of the vendors, if what role Yale played. But I can tell you that in the brief that Yale submitted in response to this lawsuit, they were pretty adamant that no discrimination was going on, and they weren't being accused of discriminating against anyone on the basis of health status. That was not what the lawsuit was about. It was strictly about the penalty amount and whether it truly was a voluntary wellness program.
And then just before we go on to the next slide, the other key thing is I believe that one of the arguments Yale made was that the unions had bargained for this.
Yes.
And the counter argument, of course, is you cannot bargain away people's civil rights.
Right. And interestingly, again, the unions that were the plaintiffs in this case were locals 34 and 35. There was a police union that also worked with Yale University or for Yale University. And they had the same health expectations program, the same preventive tests that they were being asked to do, but there was no penalty assigned or tied to getting those tests for that union. So that's an interesting dichotomy that one union didn't have the financial penalties associated with those tests, but the others did.
So the settlement.
Yes. So the case, again, was filed in July of 2019. And as of March 4th, well, they'd started having settlement talks last fall, but March 4th, so just a couple weeks ago, the Yale University filed a settlement proposal with the court that outlined the terms of the settlement. And so that means that we won't get a court opinion on this case. So the court is not going to weigh in on what it means to be voluntary. If Yale's wellness program, HEP, was in fact voluntary under the ADA, the parties decided to settle out of court. And so what the settlement agreement contains is that first, they don't want Yale's program to be obviously imposing that $25 a week fine, and they don't want to share insurance claims data with vendors without employee consent.
Okay, and we're getting at one more question here. I want to stay on time because we're only doing 45 here, but this is not precedent. Let's just be clear on this, because it wasn't the case, but it sends a message. Yeah.
So when parties settle a lawsuit, I mean, they're weighing their options. They're weighing how much is it going to cost to fight this lawsuit, and what are our chances of winning, and is it worth the cost? Is it to try to win? And obviously we weren't in the room when these considerations were happening, but both parties came to the conclusion that it was wasn't worth fighting anymore. It wasn't worth incurring any more cost. And so the plaintiffs were willing to accept, in exchange for giving up the lawsuit, $1.29 million in settlement monies, and that's going to go to the plaintiffs as well as help pay attorney fees. And then also, we didn't really talk about this other component of the complaint that the plaintiffs had. It had to do with the coaching component of the health expectations program. So in addition to asking employees to undergo these preventive tests, the employees of locals 34 and 35 were also asked to see a health coach at least 3 times if their claims data, their insurance claims data, showed certain health conditions that could benefit from coaching. And so for those people, employees who attended health coaching, they got another $225. And then some important programmatic changes that the settlement agreement addresses is that for 4 years, and it should say, or until there's a change in the law. So Yale is hoping that the EEOC will eventually come out with some rules that to define what it means to be voluntary. I'm not sure that will happen. That's another webinar, I guess. But for 4 years or until there's a change in the law, Yale's program will no longer impose that $25 a week fee. The vendors who are involved with the program will not be sending data for coaching referrals. And all data that they have collected will be purged, and there will be no penalty for refusing coaching. So before the lawsuit, there was this, if you didn't participate in the coaching, if you were recommended to see a coach and you didn't, you still had to pay that $25 a week fee. So there's coaching will be offered. It's just not going to have any incentive or penalty tied to it anymore.
So two follow-up questions, or one follow-up observation, one follow-up question. The follow-up observation would be that coaching at the point of a gun is probably not going to be very effective. I mean, I know if somebody did that to me, I'd be multitasking the whole time and just grunting occasionally. Yes, so I just get the box checked off. The second thing is, I think I know the answer to this, but a scale of 0 to 10, how would you say the plaintiffs did?
Oh, I think they did great because they got the program changes that they were looking for. I don't know what they were looking for as far as monetary relief, but they got a pretty good, I think it's a pretty good amount of money.
I would say it is. I mean, the AARP was pretty thrilled with it. And like I say, the Yale people were sulking away. And so it feels like close to a win, but you're right. I mean, unless you're, I mean, what percent of cases actually go to court anyway, right?
Yeah, not very many.
Single digits, I'd say. Yeah.
Yeah.
All right. So just to wrap.
Yeah. So the lessons that I would take away, even with the settlement, and so we don't have, a court decision that could create some precedent, but we can still pull lessons from the settlement and this lawsuit in general, is that, again, what is voluntary in terms of a wellness program that asks employees to divulge personal health information, either through asking them questions or asking them to undergo a medical exam? That's in the eye of the beholder. Every employee is going to have a different perception, but we can say that it's borne out in this case. If the employees have a particularly lower wage, the incentive or penalty is going to have a much bigger impact on them than those employees who maybe work at higher wages. And so the $25 a week penalty for those employees was too much, so much so that they were willing to bring this lawsuit. And employees are starting to pay attention to their wellness program and incentives. And I've said in my previous talks, I get calls from employees because they do Google search on wellness programs and law, and they end up calling my law firm. And so I will hear from employees who are frustrated with their employer's wellness program. And it's usually the only ones that are being complained about are those that have the financial penalties associated with these different health information collection activities.
Okay, we're getting kind of flooded with questions, so we may end up answering some of them in writing. But so let me just, as a final word before we go on to fixing it, do you think word's going to get out and the plaintiff bar is going to get involved and create more class actions, especially amongst the programs with the largest incentives or penalties?
I do. I mean, that financial settlement is a good chunk of change, and plaintiffs' lawyers, that's their bread and butter. And so, yeah, I mean, I think this is an area of law that's ripe for more action.
Okay, and then we'll get to the other questions later, but I mean, there's no way the EEOC is going to have rules in 2022. I mean, the rulemaking process is much longer, so that was an easy one to answer on the spot. So I will go back on the screen here and go through what's compliant and what's not. And Barbara, why don't you do what I just did? And when you want to make a point, why don't you go off now, and then and when I see your picture, I'll then turn to you. There's a very bright line between clinical and non-clinical ways to earn incentives and avoid penalties. So this is a list of ways that, in this particular case, I think it was Bravo, for one of its customers, how their employees could make the $500 incentive. Now, keep in mind that $500 incentive was not just added on top of some very generous program. The deductible is increased, and then employees are given the option to quote unquote earn it back. This is a little bit fuzzy, but I just wanted you to see that it's a real thing. And then we're going to take these items and we're going to split them into two. The first 5 are non-compliant. The coaching, as Barbara was just talking about, the idea of having to crash diet your way to a BMI under 28 at the time that they measure it, like that's healthy for you. Completing a risk assessment, submitting to a biometric screen, or losing weight or reducing blood pressure. All those would be considered highly clinical and completely in line or not in line with the voluntariness rule. Now, 2 things people could do was lunch and learn or claim not to smoke or attend smoking cessation. If you get tested for smoking, that's considered clinical. If somebody just asks you, that's not considered clinical. Note that people could only earn $350 this way. So this program would be non-compliant. To make it compliant, one thing you could do is simply drag employees into your lunch and learn 10 times over the course of the year. Of course, you might offer more than that. They'd have to do it 10 times. And if you give them $25 a piece, that's $250. You're compliant, but it's not a particularly good use of time. I mean, how many times can you tell somebody eat more broccoli? And if they don't get it the first time, they're not going to get it the 10th time. So yeah, you can buy more things from your existing vendor to get compliant, and they're all trying to sell you them. But you have to ask, are you just doing this to get compliant, or is there any value? And speaking of which, there are now vendors who have ADA compliant health risk assessments, where these are HRAs where they don't actually ask you about health, because that would make it non-compliant. They ask you things like, are you a good person? Now here's just an observation that if in fact you are a good person, you will answer yes. However, if you are a bad person, you will also hit number 7, that you strongly agree, because the whole point of being a bad person is to lie, right? And to cheat. So obviously everyone is going to say they're good people. So this is, yeah, it's compliant, but it's a complete waste of a health risk assessment. And as Barbara talked about, you can't really do health coaching without asking personal information, right? I mean, theoretically you could, but it would be a waste of time. Now, the best example of this bright line between what is okay, what is not violating the voluntariness rule in the ADA, And what is an activity-based program like this. Run around the block and we'll send you some money. We'll give you some money. That's compliant. There's no clinical involved. However, if you change it to run around the block and we will take your pulse and give you money, suddenly you've become non-compliant. You see the bright line there, compliant versus non-clinical versus not clinical. The ACA applies to both of these. The ADA applies only to the clinical. So, as we have just seen with the example of the lunch and learns, if you offer a choice of screening or activity-based programs to achieve your points goal, you are in compliance. That satisfies the law. You don't have to change your incentives or your penalties or anything, as long as somebody can get to their full amount without anything clinical. And however, the other thing we would note is that, and this is where the existential lemonade comes in, if in fact you don't actually offer anything clinical, that means there's no private personal health information involved and more employees will participate. But you want them to participate in something useful. Now, this will shock you, but those of you who've known us for a while, but we actually anticipated, we were kind of ahead of the game here. We anticipated this happening when we started the company, that in fact the word voluntary would get redefined someday as voluntary. So we have created a way to maintain your existing program and have it be useful and get more employees to do it and have it be completely compliant. In fact, we actually will indemnify. We will indemnify your entire program against individual claims brought to the EEOC or class actions if in fact you use this very simple Quizzify approach. One page, it's all you need. How to earn your wellness incentive. You give people a choice. Note the word choose comes here, and down below the word choice comes. You give people a choice of doing a screening or a weigh-in or something clinical, and then you lay out the criteria, just like with the police union that Barbara was talking about, where you're not forcing people to do something. You're giving people the option, and you're trying to get the people who will benefit the most from screening to do the screenings. Otherwise, you can just play the Quizzify games and learn a ridiculous amount about health literacy just by learning about health literacy without having to give up any information. And we do have an example here. What should you do if you or your kid gets a cavity? Get it filled before it gets worse? Demand that the dentist sprinkle a miracle solution on it to stop it? Or brush really well with a fluoride toothpaste and added sugar? And while we are doing that, let us do another question. So yeah, based on the salary info provided, $25 a week is less than 4% of salary, even for people making $16.92. The judge found that to be a significant amount of money. I mean, if you think about it, $1,300 over the course of a year, that's a lot of food, or it's a difference between being able to repair your car and not repair your car. I mean, it's a significant amount of money, whether it's only 4% of fees or not. So Mark, do we have answers on this? Okay, get it filled before it gets worse. 20% with the demand the dentist paint a miracle solution on it, and 10% brush really well. The answer is demand that the dentist paint a miracle solution on it to stop it. 70% of you, actually 80% of you, did not know this, and the other 20% I suspect are already Quizzify customers. Okay, small cavities no longer have to be filled thanks to an FDA-approved breakthrough therapy. It's the only dental therapy given breakthrough therapy status by the FDA, called silver diamine fluoride. This is a perfect example of what employees will learn through Quizzify, which is totally ADA compliant, but which does not require personal health information, but which will get a lot of behavior change. How much behavior change? For every 1,000 employees, for every 1,000 people you cover there are 400 cavities a year, far more than anything else, any other medical procedure. The way it works is you put a drop of the silver diamine fluoride, or the dentist does, not you, on something called a micro brush, and brush it on the cavity, and the cavity goes, oh, it doesn't go away, it ends, it stops, it freezes into place. No having to drill it. See all this healthy enamel here you'd have to drill out? No having to drill out any healthy enamel or anything, period. Now you might say, how do I know this? Well, those of you who are in my age category might remember the Hair Club for Men ads where Cy Sperling would say, I'm not just the president of the Hair Club for Men, I'm also a client. Well, guess what? I am also a user of silver diamine fluoride. I went to the dentist not too long ago, and I got to tell you, in the history of dentistry, there has never been anybody more thrilled to get a cavity than I was. Okay, so this is my own EOB. I insisted that the dentist use silver diamine fluoride. They will push back because it is so easy. Well, number one, it's so inexpensive. They don't really make any money on it. And number two, they spent all this time getting trained to fill cavities. And frankly, a trained monkey could probably put on SDF. So the employees have to know to ask. The dentists aren't telling them. That's why 80% of you got this question wrong. Now, this is my EOB. Note that that I paid, they submitted $75. Silver diamine fluoride is in fact a covered, or not a covered benefit, but it's a repriced benefit by probably half of all Delta dentals. So the approved amount was $39.92. My wife's insurance, not unlike 80% of your insurance, as we just learned, did not cover it. And yet I ended up paying $39.92 completely out of pocket instead of paying $80 or $90 for my 50% of filling a cavity. Plus, I had a meeting half an hour later and I wasn't drooling, I wasn't slurring my speech. And the thing only takes 2 minutes, just like we tell people. I was actually going to video the procedure, except by the time I got the video on, it was over. This is precisely the reason this is a great excuse. This EEOC thing is a great excuse to switch to Quizzify, or not switch, but add Quizzify to your programs so you can give employees very useful wellness tips without any PHI. Now, the other thing that is, besides activity-based programs, the other thing that is greenlit is what's known as value-based design. So for instance, a diabetic program where you cover the co-pays is considered benign discrimination. And Barbara, you want to give a little chat about that?
Sure, yeah, hi. And I think there was a question that was asked that kind of relates to this. So under the HIPAA Affordable Care Act rules, again, that prohibit discrimination based on health status, generally speaking, there is an allowance for group health plan wellness programs to treat those with underlying health conditions more favorably, meaning, you're giving them extra benefits, a bonus if they, do something to address their underlying conditions. So if you're evaluating as a group health plan and you have a wellness program for your enrollees, looking at claims data and see someone has diabetes and you offer them, free health coaching if they want to go. I mean, you're not penalizing them. You're offering them an added benefit, or you're helping them buy, more appropriate food so for their diet. Those kinds of things are permissible. It's called benign discrimination. And you might wonder, well, isn't that what was happening here with the Yale University lawsuit with the HEP and the coaching program? And no, that's not what was going on, because it wasn't. Yes, they were identifying employees through claims data and those who had underlying conditions, but they were penalizing those employees if they didn't go to a coaching session. It wasn't an added benefit. It was actually a penalty. So it has to be more favorable treatment than penalizing people.
Thank you. So just to summarize what Barbara said and what we've been saying this session is that Most health risk assessments are either unhelpful or else they're medical. Incentivized checkups are and screenings are considered clinical inquiries. Required coaching is impossible without asking personal questions. So that's the bad news. The good news is that fitness activities are okay as long as there's no clinical follow-up. Quizzify makes your entire program compliant, guaranteed, and indemnified. And value-based designs are okay. So we have one final polling question. I got to say, these 45-minute webinars really keep us on our toes. And I might also say that quite literally everybody is still on. So here's the question. What are you going to do now? Keep high incentives and penalties and take chances on non-compliance, reduce or eliminate non-compliant activities, let your vendor sell you more compliant things to protect their revenues, or add Quizzify to your program to guarantee compliance and behavior change like the cavities. And while you are doing that, let's see, I believe we have, we're going to be answering some of these things in writing. Is it out of compliance to require a biometric screen that's participation-based, not results-based? Absolutely. That was, the judge was quite clear about that in the original. It's not, this is, outcomes is an ACA thing, right, Barbara? Not an ADA thing.
Right. You're right. Yeah, so the issue is with biometric screenings for purposes of ADA compliance is that you're collecting health information. It doesn't matter if you're incentivizing the outcomes of those screenings or you're just incentivizing the participation in taking those screenings. It's the fact that you're collecting the health information that requires you to look at the whole structure of your program to decide if it meets the statutory voluntary requirement that the ADA imposes. And
Mark, what do we have? Okay. Oh my goodness, people are getting a little scared. Well, still, we do have 30% with a number of people on. That's many dozens of people who are going to add Quizzify. So thank you for that. And there are a few people who are going to buck the trend and take their chances. So good luck with that. I think that pretty much wraps it up. We do have a couple more questions in the queue. Barbara, can you see the queue from where you are?
Yes. Yes.
Is there anyone you'd like? Just to wrap? Is there one question you'd like to grab now, and we'll do the rest in writing?
Yeah. The voluntariness and vax mandate. Have we seen litigation? There's been litigation about the vaccine mandate and whether there's, as far as the government's ability to do it, and some employers have been sued. I can think of a couple of cases from last year before Biden's OSHA rule came and went. And the courts that I've seen read the decisions about mandating the vaccine in the workplace so far have been favorable to the employer. And again, the lawsuits that I'm aware of were not alleging discrimination based on religion or discrimination based on some underlying health condition. It was just a matter of principle that the employees were suing their employer as, violating their right to choose whether to get the vaccine, and the few court decisions I have read on that issue have come out in favor of the employer's decision to mandate the vaccine. And most of the employers that were being sued are healthcare related organizations, hospitals, and the courts were in favor. And even in the Supreme Court case that struck down the OSHA rules, there was a commentary by the justices that, in some industries like healthcare, it might make sense to have a mandate of the vaccine.
And while we're on mandates of vaccine, flu vaccines and that kind of thing are very specifically not part of this ADA prohibition. So employers can keep demanding those and, paying people or making them do it or penalizing. Okie dokie. Well, we finished right on time, and we would like to thank once again our very special 1 in a million or 1 in 1.3 million guests to have here. And my suspicion is this won't be the last. It's the third that we've done, and it won't be the last. And thank you all for staying on. We had a very high number of people staying on. And we will be getting back with the answers to these questions probably in the next day or two. Barbara, thanks again, and we're signing off.